Okay, welcome everyone. My name is Rachel Foskett and I'm Marketing Solutions Manager at dataxu. Thank you for joining us today for our webinar, The Marketer's Guide to GDPR. Our goal in the next 45 minutes or so is to give you the knowledge and confidence you need to prepare as a marketer for the GDPR regulation that will come into effect next year. Before we get started, we just have a few housekeeping items. Firstly, you'll be in listen-only mode to cut down on background noise. The webinar control panel can be opened and closed by clicking on the small red arrow button in the upper right-hand corner of your screen. If you have any questions during the webinar, you can send them by opening the control panel and then typing them into the question box. We'll open the floor to questions in this manner at the end. Today's webinar is being recorded and we'll send you an email with the link to the recording afterwards. So without further ado, I'd like to welcome our speakers for today's session and let them tell you a little bit about themselves. We have Andy Dale, who is our VP of Legal at dataxu, and he's joined by Noga Rosenthal, who is Chief Privacy Officer at Epsilon and Conversant, and Catherine Armitage, who's Senior Manager of Public Affairs at the World Federation of Advertisers. So with that, I'll hand you over to the panelists and let them introduce themselves. Over to you, Andy.
Hello, everyone. This is Andy Dale. I'm the VP of Legal at dataxu. I'm running the legal team as well as all privacy issues. I'm excited to be here and to talk with you about GDPR. And we've got two great panelists to discuss these issues as well. So I'll let each of them tell you a little bit about themselves and their background. So I'll let Noga go first and then Catherine.
Thanks, Andy, and thanks, dataxu, for inviting me to this great webinar. I'm Noga Rosenthal. I'm Chief Privacy Officer of Epsilon and Conversant. I deal with everything privacy at Epsilon, including our email service provider business, our marketing business, our agency business. And prior to that, I was at the Network Advertising Initiative, which is an industry group here in the US, where we set self-regulation for the ad tech industry with responsible data practices for the collection and use of data for interest-based advertising. Prior to that, I was at Xaxis, which is a Group M entity, which is a WPP entity in turn, where again, I was the general counsel for Xaxis, as well as dealing with all the privacy issues there.
So my name is Catherine Armitage. I work at the World Federation of Advertisers. The World Federation of Advertisers represents around sort of 90 different client-side marketers who have activities globally. So that includes clients like Procter & Gamble, Unilever, Mars. We also work with 60 national advertiser associations, for example, ISBA in the UK. My role at the World Federation of Advertisers is that I do everything related to digital privacy, public affairs, and everything to do with digital governance. So GDPR falls into that remit.
Thank you very much. So we're going to get started. I want to qualify everything we say. A couple of us are attorneys, so what we're talking about here is not legal advice. For anybody, just our thoughts and feelings about these issues and hopefully some helpful discussion as well. Okay, so we're going to first start with the current legislation, the lay of the land, which is the EU Data Protection Directive, which has been in place for some time. And we've been working under this directive to perform, as Noga said, interest-based advertising, which is advertising utilizing data. The general rule under the directive is that personal data may not be processed without a lawful basis for doing so. And personal data has a relatively broad definition, and that includes data like name, address, credit card information, bank statements, information relating to an identified or identifiable natural person. And those lawful bases for processing the personal data include things like contractual necessity, where that processing of that personal data is necessary to fulfill a contract made between a data subject and a party, or a legal obligation required by law, to fulfill a public interest, or another basis called legitimate interest, which we'll talk about a little bit more later. And then one other is obviously if a data subject consents, and we'll talk about that a little bit more as well. The basic framework for how the law works is that the directive is a framework, and each member state has its own law underneath interpreting the directive and its own data protection authority enforcing it. There's a group of DPAs called the Article 29 Party, which provides policy and guidance and has done so over the years. And the Working Party, for example, was responsible for kind of the development of IP address as personal data over time. Under marketing approach, we'll talk about consent being obtained via cookie banners and mobile apps, and then that consent being passed along to third parties for advertising purposes. Also, the marketing approach has involved de-identification or truncation of IP addresses and other data, as well as utilizing transfer mechanisms which have been in place to allow the movement of personal data between the United States and Europe. Prior to the current setup, there was a certification program called Safe Harbor, which you may know was invalidated and replaced with Privacy Shield, which is in place today. So now we'll move forward to what's going to happen in May, and I'll let Noga speak a little bit about GDPR, and then hopefully we can walk through some of the key questions.
Thanks, Andy. So when I look at what the impact of GDPR is to my company, one of the main things that I look at is the fact that personal data has been expanded to include things like IP address, mobile device IDs, and cookie identifiers. So any data, personal data that we collect in Europe falls under GDPR, which in turn means that, again, IP addresses and mobile IDs all of a sudden fall under the data protection rules of Europe. That in turn requires that we can't process personal data without a GDPR compliant basis, which again means that we have to have a lawful basis to, and it has to be documented as to why we're processing and collecting this personal data. The other thing too that's key here is that we can't do more business-friendly countries such as the UK for a more business-friendly review of GDPR, interpretation of GDPR. It's one regulation that governs all the member states, including France, Germany, and the UK. Going to the next slide, what it now means is that we have to look at the basis for processing this data. And there's I believe 6 bases that we could look at in order to process the data. For marketing, the most relevant one is probably legitimate business interest or consent. And this is another big impact. The redefinition of consent to me is a really big impact on every single company out there, because not only are we collecting data to help our clients market to their consumers, but our own clients, even my company, we market to our clients. And so now we have to go back and we have to look at how did we get consent. Because consent has to be freely given, specific, informed, and unambiguous. And to me, this unambiguous piece is the biggest challenge. So for instance, if I say, I'm going to collect your emails to send you marketing materials, that to me may actually not be consent, because the consumer is not saying, I agree that you may send me emails by entering my email here. So the statement has to be very clear. They have to take an affirmative action, which means that the box where they check off and say, okay, send me a marketing material, that can't be pre-checked. There's a lot of open questions under consent. The ICO, the Data Protection Authority in the UK, released guidance, I believe it was back in March or April, that many companies reviewed and commented on. And we were supposed to get back final guidance this past May. That guidance is now going to be released sometime in December. So you could see that this causes a challenge for us because we're just not sure what consent is really going to look like. But based on this, it seems that the statements must be, again, just very clear, an affirmative action. Again, for me at least, Andy, I have to say there's so much ambiguity under consent that I'm still struggling with. And the fact that the guidance won't be released until December just makes our job a little bit harder. The other option is legitimate business interest. So the other lawful basis that you could say you're processing data for is this idea that you have, as a business, this interest of a legitimate interest of reaching out to your consumers. It's not an absolute right. You have to balance out the user, the data subject, basic fundamental privacy right versus this right to reach out and have your business grow and reach out to your clients and try to get them to visit your store. The Direct Marketing Association of in the UK released really excellent guidance on legitimate business interests and how to do this balancing test. Because again, you have to document a lot of things under GDPR, and this balancing test is one of them. So one tip, for example, outside of going and reviewing this guidance, is to make sure that you're only collecting the data that you need to collect, that you have a legitimate reason for collecting that data point, and that you don't keep data for eternity. Make sure you have some retention policy, because that makes it more likely that you could really rely on this legitimate business interest. The one wrinkle in this is that for third-party ad tech companies, we are also governed not just by GDPR, but also by the e-privacy directive. The e-privacy directive is the cookie directive, that's what it's commonly called. It's why in some countries in Europe you see the little banner that says, we're dropping cookies on you if you continue on the site. We're going to assume that you want us to continue dropping cookies on you. The problem with that banner is that there's an argument that could be made that it's not, there's ambiguity. What if the consumer didn't actually see the banner? Then do you really have their consent to drop a cookie on them? And that's what the e-privacy directive requires. It requires opt-in consent for the use of cookies. For us, again, for the ad tech companies, there is this open question: can we rely on legitimate business interests? Can we not? During the last iteration of, just stepping back for a second, about, I think it was in December, we saw a leak of a draft of the e-privacy regulation. So what that means is that the regulators are now looking to revise the e-privacy directive to make it a regulation very similar to the GDPR. So it would have the same fines. It would go into effect in May 2018. And again, it requires opt-in consent for the processing of data. You know, the e-privacy reg, I truly believe that it's not going to be finalized before May 2018. I think there's a lot of open issues still. And one of those open issues is the fact that somebody did say, one of the regulators said that ad tech companies should be able to rely on legitimate business interests for their businesses. So we're left in this boat of not really being sure what the right path forward is. What should our legitimate business, what our lawful basis should be for processing data. But having said that, my recommendation to most companies is to, at the very least, start looking to comply with the other GDPR requirements, including the data subject requirements. Andy, turning it back to you.
Thank you very much, Noga. E-privacy presents a lot of questions, as you noted, and legitimate interest is not a part of it at this point. Hopefully we'll get some clarity and some guidance, but right now I agree completely that we need to focus on what our options are under consent as well. So let's move to the kind of general questions. I do want to just say one thing, Noga, you mentioned briefly, and I want to characterize GDPR a little bit for everyone who's listening. I think it's really important as we go through these questions that, particularly as a company based in the United States, that we carefully think about and be thoughtful about the reasons for GDPR and the reason for the difference in privacy approach between the United States and Europe. For the EU data subject, data privacy and data protection are fundamental rights, and in the United States, it's been approached in a little bit of a different way. So for United States companies, I think it's very important to be thoughtful and attentive to the idea that the data subject that you're dealing with in Europe comes at this from a different angle, and to be thoughtful about what you're going to do with data and how you're going to comply with GDPR in particular. So the first big pillar question is, what do marketers need to do to comply with GDPR? So I'll ask Catherine for your experience, as this is a part of what you're doing at WFA, and how are you guiding members?
Yeah, thanks, Andy. I think that we've covered a few of the key elements of the GDPR in the previous slides, and I think that we've been working a lot with client-side marketers to help them understand what are the key things which need to be understood. It's worth bearing in mind that, you know, most client-side marketers are, you know, big global companies, of course. So there's a lot of behind-the-scenes work that has to take place, first of all, just to understand what data is owned and used and processed, and where is it. And that's kind of the first major step, I think, for all marketing companies, is to really do a full sort of inventory check of the data, and that includes, you know, data that's owned by the company, but also data that's flowing through and being processed with third parties as well. For big global companies, that's for many companies, that's a huge piece of work in itself, because, as you know, in many companies there will be different business units, different countries, different teams working with different bits of data in different ways. So the GDPR kind of forces companies to really take a good look at what they have, and if necessary, even do a bit of spring cleaning. I think that one of the things that comes up most often, at least with WFA members, are questions around consent. So, you know, as we've seen, the GDPR introduces some new, more stricter rules around what consent means in order to be able to process personal data. And so many marketers are now looking at all of the consent mechanisms and tools they have across all of their marketing assets that are consumer facing, in order to assess whether they comply, and if they don't, how to comply, and at the same time, you know, make sure it fits in with whatever marketing campaign is running. I've talked a bit about consent, but of course there's also in the GDPR a number of elements requiring businesses to be also transparent about how they are processing data and for what purposes. And in a nutshell, what that means for many companies will be that they have to provide more information about what data processing is taking place at the point of contact with a consumer. So it's a big challenge, I think, actually, for marketers, how to be transparent without sort of drowning the consumer in lots and lots of information and adding, for example, extra steps into the consumer journey, which actually could have an impact on the way that consumers are interacting with the brand online. So I would say that consent is the second one. And finally, and perhaps most relevant for today's webinar, we would advise many companies also to sit down as much as possible with all the partners, third parties and agencies they work with, to really understand how they can work together to assess compliance with the GDPR across all parts of the data value chain. Because, of course, the GDPR, there's one thing trying to assess whether you comply with the GDPR in terms of collecting data directly from consumers yourself. but what about the indirect collection of consumers' personal data? How to ensure that everybody is on the same page in terms of what compliance even means, what consent looks like. As we've seen, the way that it could be interpreted actually could vary from company to company. So it's important that at least everyone in the value chain has a common view of what compliance looks like in order to avoid any nasty surprises down the way.
You bring up a good point that I want to add to, which is the sort of overall compliance aspect. So in addition to all of the things that we've talked about with respect to trying to process personal data for advertising, if a marketer or a company has data of EU data subjects and is moving that data back and forth and is processing that data, there are heavy new compliance programs that need to be put in place. And you really, if you step back, GDPR, a large piece of the structure is implementing privacy as its own department within a company that is processing this kind of data. So it's building a compliance organization. It's being more transparent in notices and practices, as you noted, and it's also doing diligence on partners. That's baked in and built into GDPR, and it's sort of, in my view, it's Europe leading the United States towards a place where companies that are global need to be more forthcoming and more responsible and more open about their practices, and really build a privacy by design culture into the development of the technology and into the way that they utilize the data that we're talking about. So if there's nothing else on this, we can go to the next question. So what is the technology provider's responsibility versus the marketer's? This is an interesting question, and it sort of relates to some of the things we've been talking about. And I think it sort of relates to diligence as well. The technology provider itself is going to have certain obligations, I think, but also we need to talk about what the publisher obligations might be. And so I'll open it up to you guys. Do you have any thoughts as well on the technology provider versus the responsibility of the marketer themselves?
So Andy, what I would say is that, I think both of us have a responsibility here. I think that at times the marketer is in a better place to get, depending on the service, right? The marketer may have a better ability to get consent from the consumer, and then the processor has to rely on that consent. So I think it depends on where we sit in the ecosystem and what the service is.
Any other thoughts on the technology provider piece? I think we could talk a little bit more about this on the publisher side as well. But the one other thing that I would add is it's possible that website publishers are going to look to the technology for some sort of consent solution or advice or guidance on how to obtain consent. Even in a situation where they may be better situated to get that. All right. So the next question, which we've gotten a lot of, is what impact will Brexit have on GDPR and marketing? I'll perhaps let Catherine speak about this a little bit. At a high level, though, my understanding is that that UK will comply with GDPR, although there's potential for a little bit some differences.
Yeah, well, I think that if we look at the GDPR on its own, what we know is that an equivalent level of protection to the GDPR will still be needed to process the data that relates to offering goods and services in the EU or monitoring behavior in the EU. So that actually applies to any country outside of the EU right now. So it's the same for the US. The US needs to demonstrate that they have safeguards in place that mean that the data related to offering goods or services in the EU or monitoring behavior in the EU meet the standards set out in EU data protection law. Now that the UK is leaving the EU, legally, they would still need to be able to demonstrate a level of compliance if data relating, as I said, to offering goods and services in the EU or monitoring behavior in the EU will be processed or used in the UK. So regardless actually of what the UK government decides to do, whether or not they implement the GDPR as such, they would need to have something in place that shows the EU that level of protection is being met for EU data. I think that's quite an important thing to bear in mind because, you know, data transfers are really important, and, you know, as many of you on the call have seen from the experience with Safe Harbor and now Privacy Shield, that's something which is really fundamental. The UK, I believe, is now looking at implementing a Data Protection Act that will meet many of the obligations laid out in the GDPR, but I'm not an expert in the UK legislation. But what I would say is that at least from a WFA member perspective, all of our members are global companies which have business across the world in EU and outside the EU and in the UK. And so for many of them, you know, there will be an obligation that whatever happens, they will want to continue to process data relating to the EU, relating to goods and services in the EU, or monitoring the behavior of consumers in the EU, which means they still need to be able to show that they're GDPR compliant.
Do you have any sense?
One more thing.
Go ahead, Noga.
So GDPR is going to actually go into effect prior to the UK leaving the EU union. So, I'm sorry, the EU. So either way, for us, as we're looking to what to do for our UK business, you have to come into compliance with GDPR even for your UK business.
Yeah, exactly. I mean, given there's a huge level of uncertainty, I can't see many companies that would be in a position to say, well, let's not implement the GDPR and let's just wait and see. Maybe the UK won't implement it, because that would be an enormous risk and even would mean that there's a period during which you're not actually compliant.
Do either of you have a sense whether the UK's equivalent law will the likelihood of being in effect at the time GDPR becomes effective?
I think it's a question of how long the Brexit negotiations will take as well, which we don't know right now really. But I think one of the big risks that the UK needs to consider is the fact that actually, from a legal perspective right now, the current UK legislation, the way that data protection law has been interpreted in the UK, actually wouldn't necessarily meet some of the standards laid out in EU law, because there are some elements of the UK legislation which enable the government to have access to citizens' data in a way which is not necessarily compliant with the EU's law on that. And that's actually one of the issues that was at stake with the negotiations between the US and the EU on Privacy Shield. And so, in fact, I think the UK will have to make some changes to government access to data in order to meet some of the requirements and avoid the same situation that we found ourselves in with EU-US transfers, where the jurisdictions actually disagree on whether or not they meet the standards, and it's open to legal challenge. So that's a slightly different point because it doesn't relate directly to sort of protection of personal data in the sense that we're looking at in this webinar. But I think it's an important thing to bear in mind, and I'm very aware that I'm sure the UK is looking at what happened with Safe Harbor and Privacy Shield very carefully now, to think that they would like to try and avoid that, because you can imagine the amount of economic disruption and uncertainty for business that something like that would cause, especially in the wake of Brexit.
Absolutely. All right, so it looks like we have about 15 minutes left, and I want to reserve some time for questions. So we've addressed some of the additional questions already. I will just sort of quickly answer what is the difference between GDPR and e-privacy, which is the next slide. Basically, e-privacy covers electronic communications like websites, apps, messaging. That's really much of that data is certainly what's relevant for advertisers and advertising. So we have to pay very close attention, obviously, to the privacy regulation and what happens there. We've also already covered, I think, the next question, which is opt-in consent required for use in advertising, and we've also talked a little bit about publishers getting consent. I'm not sure, do either of you have additional comments on any of those? I think we've covered some of those points, but I don't want to, if anyone has other thoughts, I don't want to go ahead and skip them. Anything else on those? Okay, I think we can also move ahead, if it's okay, to the impact on television. And I think this is an interesting one, at least from my perspective, and I'll hear the thoughts of the other panelists. From my perspective in the United States, we're undergoing some changes in this space as well. The addition of innovative technologies seeking to serve addressable television ads through different medium, one of which being connected TVs, Roku, Hulu, Apple TV, those types of devices where there's a digital connection between consumer and advertiser, and actually the accessibility of certain kinds of data. So my overall take on this is obviously GDPR is going to apply to this where there's personal data being processed. And I think so we need to obviously take those principles into consideration as we develop and think about the ways in which we use data and new technology. One thing I'm hopeful that will come out of this is that if there is certainly a requirement for consent, and particularly then in the United States, if you're going to utilize data which is really tied to what a consumer has actually been viewing or looking at, and you're tying that data to personal data like IPs or cookies or mobile device IDs, that actually requires consent in the United States currently, and I can't see that being any different in Europe, certainly. So I think a lot about what will the value exchange be like between the consumer, the data subject, and the advertiser, as well as the relationship with the TV provider. So I'm hopeful that this all leads to a more transparent value exchange for the use of data in this manner. That's my personal thought on the matter, and I'd like to open it up to you, to the panelists as well, if you have any thoughts on television and how GDPR might have an impact.
So I think from our point of view, as television evolves to collect more and more personal data to enable a sort of personalized service, this will come under the GDPR. I think it's important to be clear that, that as we've discussed, the definition of personal data under the GDPR is very broad. And most importantly, it's not specific to any particular platform. So whether that data is being collected through your computer or through your television, that's kind of not really the most important thing. The question is what data is being collected and how is it being processed.
Okay, do you have anything on TV, or you're in agreement here?
Yeah, I'm in agreement. I think all the challenges we're facing online may get even more challenging on TV, because how do I if you're sharing a TV with your wife, who am I getting consent from? How does that even work?
And it extends to the Internet of Things as well, correct? So any sort of device where the user interface is unclear or new, or we need to develop a way which is GDPR / privacy data protection sensitive and thoughtful. Okay, well, should we go to the next? So what will happen if you're not compliant when the law changes? Well, this is sort of typical, I think, lawyer answer. It sort of depends. But some of this is an organization's speed, timeline, getting up to speed and getting compliant. And so are the walls going to immediately fall down? No, but it's going to have a definite business impact if your company's not ready, and if you're in advertising, particularly on the technology side, you won't be ready, and you won't be able to field the questions that are going to be asked, such that you want to be able to continue to provide value to your customers. Obviously, we know the fines and the potential are large, and I do think that may have an impact on how organizations react. But this one is a tough one for me.
Andy, so I heard something the other day that I think helped me put things into perspective, because as the deadline looms, I have some executives being a little panicky now, just wanting to make sure that we're in compliance. And so what I would say is that, look at your overall business, look at what you need to do to come into compliance, just a very general plan, and start with those that have the most risk, that have, where you're holding the most sensitive data. That's where I would start, and I would just bring those into compliance as quickly as possible. And the other points, again, there's so many things that you need to paper. Again, I'm looking at it as where do I have the most risk? What do I need to do to give comfort to my clients that we're in compliance with GDPR, coming into compliance? And I started there.
I think that's a good point. So I would add to that, as you're looking at implementing GDPR, and for example, looking at the diligence that you might do with third parties where personal data is being shared back and forth, obviously, I think it makes a lot of sense to take a risk-based approach. Where are my largest providers? Where is the risk highest? And let me address and do diligence with those partners first. Amend contracts where necessary. Ensure there's a transfer mechanism where necessary. Things of that nature.
Yeah, because Andy, some companies are facing revising around 5,000 vendor agreements. So it's a question of, when you look at that, the panic sets in, and it's like, well, how do I deal with this? And again, I think your advice is great. Look at your big vendors first, start from there, and go down.
Great. So I want to ensure we have enough time to field a couple questions. Perhaps, Rachel, why don't we skip the DPO question and just go to the last question, which is, do you think these laws will eventually be applicable globally? I'll let the panel comment first, and then we'll go from there. Do you all have thoughts on what the impact might be in other countries?
Well, yes, I think from a compliance perspective, for many global companies that have operations in countries across the world, of course, it's natural to look at the highest common denominator in terms of ensuring that you're compliant, right? So if you're compliant with the strictest laws, which in this case would be the GDPR in most cases, then indeed you can think that you're probably going to be okay across a number of other countries, even if actually in some jurisdictions you could have less protections in place. But at the same time, implementing something that is a higher level of protection sort of voluntarily also has its downsides and its risks. I think that one thing that I would say is that the GDPR is now being held up in a number of other countries as a kind of example to look towards, as a kind of best-in-class example of how to ensure you have very high privacy standards. Saying that, it may take some time because I think many other jurisdictions would be interested to wait and see how the GDPR actually evolves once it's come into force, what impact it has, and eventually, you know, all of those little questions about how it will be interpreted. What will that mean for actually, you know, how people are using the internet? What will be the impact on business? I think it will take some time for those things to become apparent before some jurisdictions would want to start introducing the same.
I think the United States will take the wait and see approach. Noga, do you think that this will lead the United States eventually down the road to a similar path? In part, probably, if it works, if it's viewed as working to create potential enforcement opportunities?
Yeah, I mean that's one of the issues that we're looking at. You know, is could the fact that, for instance, if we have to get consent on the ad tech side, could that end up reaching here? It's a tough question. I'm not really sure, Andy. I'm hoping not, frankly. I think that just based on what we saw in certain countries around consent, especially online, I just find it to be so disruptive to the user that I want to wait and see what happens, what happens not just to the data subject, you know, do they get annoyed with all these consent requirements? Because now, you know, I mean, realize it's not just ad tech, right? It's everything. You're going to have to consent to so many data uses. At some point, there's just going to be fatigue where I'm going to stop reading all those notices and consent mechanisms.
Right. So it can be viewed as antithetical to the privacy purpose. In a sense.
Yeah. And also, Andy, exactly. I mean, you know, realize that on top of it, that, you know, people always say that consent is this golden standard, that it's wonderful. And I look at it a little bit more cynically that, you know, what are you consenting to? When you consent to some of these data uses, do you really understand what's going on? And so I'm not a big fan of consent per se. And so I wonder, you know, I think there's a good argument to be made against consent, against this idea of this path, you know, coming into the U.S. But having said that, it's so difficult to manage your business complying with various laws. And as we see in Asia that they're starting to also put in laws very similar to Europe, you know, are we at some point just going to throw up our hands? I'm not sure.
Well, I think that's as good a moment as any to move towards the end. I mean, I think those concerns are very real, but I think inside of all of those concerns, there's still obviously a massive market and a massive business opportunity where advertising fuels content and the internet. So I think we're all hopeful that we will all find a way and keep using data and keep and be able to do so in a compliant way that works. So we're all working on it, and we're all confident that we're going to figure out the way forward. So Rachel, if there are any questions, we can take them or
Yeah, thanks, Andy, and thanks everyone so far. We do have just a few minutes left, so I'll open it up to questions from the floor. So we have one coming in now. Why is there such a marked difference between EU data law and, for example, the US law?
I think it relates to what I think, in my view, what I mentioned earlier, is that the underpinnings and fundamentals are different. The United States has taken a different approach. The data subjects in the EU have a fundamental right of privacy, particularly around, in this instance, around the way data is used. And so I really think that forms the basis. The United States has taken a very sectoral approach with specific laws addressing sensitive data, elements like health and finance, and how that sensitive data is used so as not to make users uncomfortable or expose data unnecessarily. Whereas I think the approach in Europe has been broader, more focused on fundamentals, and I think that's likely to stay similar, but as we noted before, it'll be very interesting to see the impact of GDPR, as Catherine noted, over time.
Yeah, I think I would just add on that. So I'm based in Brussels, and we have been following very closely the latest discussions on the new e-privacy regulation, which we discussed at the beginning, that's currently being reviewed. And one of the things that comes up time and again with the policymakers and the legislators in Brussels is that, in fact, they see that there are two fundamental rights which need to be protected in the EU. One is the right to data protection, which actually in itself is a right. And also the other, which is more to do with e-privacy, is to talk about the right to private life as well, which, you know, originally actually was not a right that was designed for the internet age, but increasingly as we live more and more our private lives online through our devices, that has become applicable. So you have this kind of double whammy in the EU of two things which combined have a very, very strong cultural and historical importance in the EU. And one of the things that became very apparent during the Privacy Shield negotiations was that, in fact, one thing to remember is that at EU level, where these fundamental rights are enshrined, we don't really talk that much about national security, because in the EU, national security is something which each individual country owns. So the fundamental rights are set at EU level and enshrined in things like the GDPR, whereas national security is something which each individual government needs to protect and manage itself. And I think that's one of the tensions which comes across when you start looking at, for example, the US, where national security is, of course, a huge priority for the government. And that has to be played out actually directly in tension with privacy, whereas actually in the EU, that balancing act between national security and privacy is not something which actually ever has to be discussed that much at EU level, because of this kind of this weird thing about a national level and a kind of federal level. So it's an interesting tension, and I think that that's one of the things which marks, for me certainly, one of the differences that we see between the US and the EU.
Okay, thank you. I think in the interest of time, we'll wrap it up there, actually. So thank you again to Andy and Noga and Catherine for joining us today. We'll follow up with any questions that haven't been answered. And I hope you all have a great day.
Thank you.
Bye.